Foundations of Justice, the American Legal Legacy. The law is reason, free from passion. Aristotle. From the marble halls of Washington to the bustling courtrooms across 50 states, the American justice system stands as one of the most intricate and storied institutions in history. But where does this system come from? What philosophies underpin its power? Who built it, and why? The origins of law before America. Law as a concept predates nations, kings, and even religion. The earliest known laws arose from the need to organize increasingly complex societies, distribute resources, resolve disputes, and establish a moral code. The Code of Ur-Nammu, circa 2100 BCE, originating in the Sumerian city of Ur, modern-day Iraq, was written under the rule of King Ur-Nammu. It was deeply rooted in religious authority, believed to be divinely sanctioned by the god Nana. Penalties included fines or physical punishments such as mutilation. Example, if a man commits a murder, that man must be killed. The Code of Hammurabi, circa 1754 BCE, composed by King Hammurabi of Babylon, is one of the most well-preserved ancient legal texts. Etched into a stone stele, it governed commercial, family, and criminal law. Hammurabi claimed to have received the laws from Shamash, the god of justice. This society operated under strict hierarchies, punishment varied by class. Example, if a noble puts out the eye of another noble, his eye shall be put out. If he puts out the eye of a commoner, he shall pay a fine. The 12 Tables, 451 BCE, Rome developed by the Roman Republic. These laws were etched on bronze tablets and displayed publicly in the Forum. Drafted by a board of 10 men, decemviri, they marked the shift from oral custom to written law, emphasizing transparency. Punishments included exile, death, and fines. For example, a dreadfully deformed child shall be quickly killed. These ancient laws derived authority from divine or communal belief and embedded social norms into a legal framework. From these early codes came a bifurcation that still defines law today: natural law and positive law. Types of law: natural versus positive law. Natural law, often referred to as God's law or the law of nature, asserts that certain rights and morals are universal and inherent. Natural law is a reflection of morality embedded in human nature or divine order. Biblical law, e.g., 10 Commandments: thou shalt not kill, thou shalt not steal, these reflect moral imperatives that transcend time and culture. Biblical law, especially from Exodus and Leviticus, informed early Western conceptions of justice and were considered divine mandates. Aristotle argued that law should reflect virtue and the telos, purpose, of human life. Thomas Aquinas, in Summa Theologica, declared natural law as the rational creature's participation in the eternal law. For Aquinas, unjust laws were not true laws. Law of nature was a separate philosophical construct, emerging from observation of the natural world and human reason. Cicero claimed, true law is right reason in agreement with nature. Positive law is law enacted by proper authority or institution. It is human-made and does not need to be moral, only legal and enforceable. Thomas Hobbes, an English philosopher, in Leviathan, 1651, believed in a social contract where people gave up freedoms to a sovereign in exchange for order. Law was essential to escape the state of nature, which he famously described as solitary, poor, nasty, brutish, and short. Jeremy Bentham, a legal positivist and founder of utilitarianism, dismissed natural law as nonsense upon stilts. He believed law should maximize happiness and be judged on outcomes, not origins. Hobbes came from Civil War England, a time of chaos and upheaval. Bentham emerged in Enlightenment London, championing rational reform, legal codification, and utilitarian ethics. English common law formed the bedrock of American jurisprudence. Originating after the Norman conquest of 1066, it evolved from a patchwork of tribal customs into a unified legal system. William the Conqueror instituted royal courts and brought consistency to legal judgments. Henry II, 1154 to 1189, transformed English law by establishing traveling justices and the principle of stare decisis, the doctrine of precedent. His reforms laid the groundwork for trial by jury and central court systems. The Magna Carta, 1215, imposed limits on royal power and protected barons from arbitrary imprisonment. Clauses such as Clause 39, no free man shall be seized or imprisoned, except by the lawful judgment of his equals or by the law of the land, directly inspired the U.S. Constitution's due process guarantees. Prominent contributors to common law. Edward Coke, his commentaries on Magna Carta informed American colonial legal arguments. William Blackstone, his commentaries on the laws of England, 1765 to 1769, became a legal Bible in early America.